Hello, everyone, and welcome to Uncivil Law. And for today's story, we have a case where the police shot a guy in the back after he had already been searched for weapons and was fleeing the scene. And the question is, can the guy sue for damages? This brings us to the case of David Goffin versus Arkansas in the city of Warren. So this guy was a suspect by the police. They came, they did a body search very poorly, it's going to turn out. They did a pat down very poorly. They didn't find anything on him. And then he started to flee, and then he shot him in the back. The question is this legal? Or is this a violation of your rights? Let's find out. In September of 2012, Goffin's uncle, Tommy Reddick, reported to Officer Ashcroft and Officer Aaron Hines that his home had been burgled and suspected that Goffin was responsible for stealing 2 handguns, a box of bullets, and a bottle of painkillers. Reddick told the officers that earlier that day, Goffin had come to his house and asked for a gun, explaining that he'd lost his own pistol fleeing from the police. Okay, so right away off here, this is nice little stuff. So apparently, Goffin comes to his neighbor and doesn't say, "Hey neighbor, can I borrow a bag of sugar?" He says, "Neighbor, can I borrow a pistol?" And he says, "Why?" "Because I lost mine earlier when I was running away from the police." Okay. He apparently said no. Probably that's a good answer to that question. So he just took it. All right. Reddick refused and he left the house. When he returned, he saw Goffin was still nearby, arguing with a man in a black pickup truck. Once inside the house, he discovered that someone had snuck in through a back window. Who could it be? Broken down a bedroom door and stolen guns, ammunition, and pills. Reddick warned Officer Ashcroft, "This dude is out of control, and you better be ready to fight when you find him." So, yeah, this guy has reported that, my neighbor says, "Can I borrow a gun?" "Why?" "I lost mine earlier when I was running from the police." I'm going to go with no. And then he comes back, and what do you know? His house has been broken into. And he sees this guy arguing with another guy nearby. And he's like, I wonder who it could possibly be. Maybe it's this guy. So he calls the police and says, "My gun has been stolen. I think it was this guy." The police probably says, "Why do you think it was him?" "Well, he asked me earlier if he could borrow a gun because he lost his when he ran away from the police. And then my home was broken into when I said no." So kind of putting 2 and 2 together on that one. And he says, "You might want to be careful." So the police here are thinking to themselves, well, this guy might be armed and dangerous, which at this point is a perfectly reasonable thing to believe. But of course, things are going to change that make this belief a little less reasonable. So let's figure out what happens next. After Officer Ashcroft interviewed Moore, Officer Hines called her and told her that Goffin was at a nearby body shop. In the front of the garage, the officers found Goffin sitting in his car, talking on a Bluetooth headset. Both officers approached the vehicle with guns drawn, but before they got there, Officer Hines holstered his pistol and drew a taser. So they find the guy at a nearby body shop in his car. He's still in his car near this body shop. Okay. The officers then demanded that Goffin exit with his hand raised, which he did. They then escorted him to the back of the car, and this is where it gets something interesting on terms of the police and their competence. And Officer Ashcroft claims she saw something bumping in Goffin's right front pocket. Perhaps we should try to figure out what that was. Goffin denies that anything was in his pocket, but you just saw something, didn't you? At the back of the vehicle, Goffin says that Officer Hines patted him down and searched every part of his body, including feeling for items in his pockets and around his waist. Okay, so this is just super fun. So Officer Ashcroft over here says, "I think I see something bumping in his right front pocket. Something big that might be moving around." And Officer Hines, his partner, says, "Okay, I'm going to do a Terry stop. I'm going to do a frisk." At this point, we are well within the bounds of Terry. At this point, we have reasonable articulable suspicion, and we're probably beyond that to probable cause at this point because we have an active report from a guy who says, "Hey, I think this guy stole my guns because he asked me for a gun and the guns aren't here anymore." So we might be a probable cause. We're definitely a reasonably articulable suspicion. So we can absolutely do a brief detention and we can do a pat down under these circumstances. No problem. And then Officer Hines over here does a thorough pat down and searches every part of his body. And Officer Hines over here, having done this thorough pat down, was unable to find anything. So at this point in the story, the officers don't believe he has anything on him. So the officers should not believe that he's a threat. Was that true in reality? Well, that brings us to the next part of the story. Officer Hines started to place Goffin in handcuffs, but before he could finish, Goffin pushed off the car and fled towards a group of 7 or 8 bystanders. With his back to the officers, and this is where the shooting in the back comes from, he raised his right shoulder, which Officer Ashcroft interpreted as a reach for something in his pocket or waistband. But how's that possible? Because you just saw your fellow officer conduct a thorough pat-down, and he didn't find anything. And then Officer Ashcroft just shot him once in the back. Goffin says he took no more than 2 steps, so it was very, very quick. And Officer Ashcroft agreed he made it only a very short distance before she fired. After he was shot, officers discovered the pat-down had missed a loaded 9mm pistol magazine and several loose billets. Well, that's just super promising. We were unable to find the loose magazine and the loose bullets that were in his pockets, the thing the officer felt around. So apparently officers, when they can do a Terry search and they can do a pat-down, are really, really bad at it. Because even though they thought, for very good reasons, this guy might have a gun on him, and even though they conducted a very thorough pat-down, they were unable to find the magazine and bullets which were in fact on his person. That's great. That's the way to go. But of course, because the officer's knowledge at this point would be he didn't have that, right? Because they had just done this thorough pat-down. So the officers now believe that they know for a fact he doesn't have anything on him, even though he does. So as always, usually in these situations, we are looking to the officers' perceptions and what they knew or didn't know. So at this point, what they think they know is that guy doesn't have anything on him, even though he does. And so if they shot him in the back, not believing him to have a weapon on him, can they do that? Let's discuss. Goffin survived the gunshot wound and brought a 1983 action because of course he did. We analyzed cases involving the use of deadly force against a fleeing suspect under the 4th Amendment, under Tennessee v. Garner, which is absolutely the leading case on exactly this point, Tennessee v. Garner. Pretty famous case in this domain, which involved pretty much this exact fact pattern. The state of Tennessee shot Garner as he was fleeing in order to stop him from fleeing. And the Supreme Court said, no, you can't do that. You can't shoot someone merely to stop them from fleeing, right? So that's Tennessee versus Garner. We have a case on this specifically, a fairly famous one, in fact. So you can't shoot a fleeing suspect merely because he's a fleeing suspect. He has to be posing a threat to someone, anyone. So if he's fleeing and he's also posing a threat while doing so, then yeah, you can shoot him for posing a threat. But merely for fleeing, not so much. So at this point, the officers believe that he doesn't have anything on him. So, that seems like Tennessee v. Gardner. An officer's actions are justified when they're objectively reasonable in light of facts and circumstances confronting the officer without regard to the officer's underlying intent and motivation. Yeah, we don't look to the officer's intent, what they hoped for. We don't look to their motivation, like animus or anything else, for better or worse. We just look to objectively reasonable in light of facts. Objectively. I know these words. Objective means we're going to do some kind of reasonable man test, or maybe a reasonable officer test, something like that. We're not going to ask what this particular officer believed. No. We're going to ask what an ordinary normal person, or maybe what an ordinary normal officer would do in that situation. That's what makes it an objective test. And so an ordinary or normal officer in this situation, having just conducted a pat-down, should not believe the guy has a weapon on him because he just conducted a pat-down. So in the face of this objective evidence, how could they possibly shoot him and it still be okay? The court's going to tell us in a minute. Yeah, that's where we're going. Why is this totally cool? Yep, let's press on. Officer Ashcroft is entitled to qualified immunity if her conduct did not violate clearly established statutory or constitutional rights of which a reasonable person would have known. Goffin must identify either controlling authority or a robust consensus of cases of persuasive authority that place the statutory or constitutional question beyond debate at the time of the violation. Tennessee v. Gardner does seem kind of on point. It's from the U.S. Supreme Court, so that's controlling authority, right? By the time she confronted Goffin at the body shop, Officer Ashcroft objectively and reasonably knew that they believed he was dangerous. At that time, yes. She knew that he had lost a gun while fleeing from the police earlier, yes, and had strong evidence that he had recently stolen two more. At that point, yes. Moore told her Goffin was drunk and he threatened her with stolen guns. And to top it off, Goffin's uncle had warned her that Goffin was spoiling for a front. Yes, at the time that they arrived at the shop, this would all be true. This case then turns on whether the pat-down changes our analysis. Well, it seems like perhaps it should, because again, we're looking at this from the position of an objectively reasonable officer. And the objectively reasonable officer would, at the point that they arrived at the body shop, feel like this guy might be a threat for very good reasons. But then, having conducted a pat-down, one would think that might change what is objectively reasonable, since new information has come to light. Namely, the guy didn't have anything on him, or so you believe. So maybe that's something material, yes? So this case turns on whether or not that makes any sense. Goffin argues the pat-down creates an issue of material fact. If it occurred, then Officer Ashcroft must have known he was unarmed. That seems reasonable. Or at least there's an issue of material fact as to whether she knew he was unarmed. Yeah, that seems perfectly plausible. If this happened, the officer must have known, or there would be at least an issue of fact. Right. But then whether probable cause exists is a legal question, not a factual one. Yes, that's kind of true. Yeah, but it's based on facts. He therefore must provide a case clearly establishing a pat-down that recovered nothing, eliminated Officer Ashcroft's objectively reasonable belief he was armed and dangerous. Okay, so we need a case for this. We need a case for the proposition that having conducted a pat-down and having found nothing, that it would be objectively unreasonable to believe that he had something on him. Goffin fails to point to such a case. He relies on Tennessee v. Garner, but that case stands for a general proposition. So general, that cannot establish a rule in most cases. A really general proposition of you cannot shoot a fleeing suspect in order to stop them from fleeing. Super general. In a prior case called Wellett, the parties disputed whether an officer had seen the suspect throw down a gun and raise his hand to surrender. We reversed that because the district court had improperly construed the record in favor of the officer moving for summary judgment. Yeah, so if there's a question of fact as to whether the officer did or did not see this, and that would change the analysis, then yeah, you have to go back to trial and figure out whether the officer did or did not see it. The district court did not make that mistake here, and it's undisputed that Officer Ashcroft never saw any items removed from Goffin because his partner didn't find any. He couldn't possibly have saw him remove anything because his partner didn't find anything in order to remove them. But he presumably did notice his partner conducting this very thorough pat-down. And even if, well, it were factually analogous, which it cannot put Officer Ashcroft on notice that her conduct was illegal because it was decided 4 years after Goffin was shot. So, yeah, even though, well, I mean, as to, well, yeah, that wouldn't give notice, but maybe Tennessee v. Garner does because it's like a landmark Supreme Court case, pretty big deal case, well known in this area. It was a big deal. You can't shoot someone merely for fleeing. They actually have to pose a danger. But no, that's too general. We need to find something specifically on point. Something specifically on point for the proposition that a pat-down that does not reveal anything would change what is objectively reasonable to the officer. We therefore conclude that Officer Ashcroft is entitled to summary judgment because it's not clearly established that after observing a pat-down that removes nothing from a suspect who an officer reasonably believes to be armed and dangerous, an officer cannot use lethal force against that suspect when he flees and moves as though he's reaching for a weapon. Once again, I'm going to repeat that merely so that we all can truly appreciate this because I feel like it needs to be said again. We conclude the officer is entitled to summary judgment. The officer wins because it is not clearly established that after observing a pat-down that removes nothing from a suspect who an officer reasonably believed to be armed and dangerous, that would not change what you reasonably believe in some way, even though you observe the pat-down that removes nothing. Somehow it would not change your objectively reasonable belief. Okay. There's no case that establishes that. Okay. So because there's no case that establishes that, therefore, it's not clearly established an officer cannot use lethal force against a suspect when he flees, as moves as though he were reaching for a weapon, which you would think is impossible because you just conducted a very thorough pat-down and observed nothing being removed. So how could he be possibly reaching for a weapon? But somehow, the fact that he could be reaching for a weapon is objectively reasonable under these circumstances, or at least there's not a case telling us otherwise. Nor do we think this is a rare, obvious case. in which the unlawfulness of an officer's conduct is sufficiently clear, even though existing precedent does not address similar circumstances. No, this is not an obvious case where the conduct is sufficiently clear to the precedent. There's nothing there, guys. Okay, well, let's go back to the top and end this thing. Thus, that brings us to the end of the case of David Goffrin versus the City of Warren in Arkansas. In this case, decided by 8th Circuit Court of Appeals, the police thought this guy might be armed for fairly decent reasons, and they found him at an auto body shop. They then conducted a very thorough pat-down and didn't find anything on him. And so you would think that might change their objectively reasonable belief. But even though you might think that, they shot him. And then the Court of Appeals says, hey, wait a second. There's no case that clearly establishes that a pat-down that reveals nothing changes your objectively reasonable belief as to whether or not the guy has a weapon on him. You thought he had a weapon on him before. You conducted a very thorough pat-down that revealed nothing. And there's no case that establishes that given all that, you can't still objectively believe that he's armed. So David Goffin is unable to recover for being shot by the police in these circumstances, and that brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you liked this latest video, please give it a like below and hit the join button. For 99 cents a month, you too can give a recurring membership that helps this channel grow and helps YouTube to recommend this channel to others. We really appreciate your continued financial support and all your love. And until later, my friends, cheers and goodbye.